Okay, so this is an important act that applies now when we're talking about all these protests, really, just to get an idea of the legislation, what it should be. So this is the Public Bodies Admission to Meetings Act 1960. Now this is later than the Public Meeting Act 1908, but this is the one that the police normally refer to. And this is why the police don't really know about the normal Public Meeting Act, which applies to us wherever and whenever we want to have a meeting of our own choice, right? Now, this 1960 Act is for certain authorities, okay? Certain authorities. I don't think it includes local councils, but similar. There are different government bodies which can have the public into meetings. I don't think it covers the London Assembly either, but there's a list in the schedule anyway, right? The schedule's here. This is a schedule, what it applies to, right? But it's been, a lot of it's been repealed. But just to give you an idea of what we're talking about, so bodies to which this act applies. So we've got all local authorities within the meaning of the Local Government Act 1933 or the London Government Act 1939. The Common Council of the City of London, the Council for Houses. So it does apply to some local councils, water boards, National Health Services, different committees and joint committees on policing. All these different committees are which it applies to, right? Now, the law says that those authorities can have a meeting where they do not invite the public to the meeting. They're allowed to do that. They're allowed to have a meeting which exists and opt not to have the public there, right? But if they do opt to have the public there, okay, once they've opted to have the public there, then the actual meeting is privileged. So anyone who attends that meeting is privileged, kind of a little bit like parliamentary privileges, but privileged to that meeting under the authority, right? So that means that, you can't be removed from it or prevented from laying evidence as long as, you're in order. This is why they call order. In America, they've just had consent proceedings and, there was people shouting out in the audience and, they remove them. But really those persons who get removed, they're only if they're preventing a certain person from speaking their turn, but they might not be preventing someone else from speaking. And if it's a meeting where, people are allowed to speak and are allowed to have a turn and have got a right to have a turn, they've got to have the turn, right? So really, you've got to kind of really be disrupting the order of proceedings or preventing other people from doing anything. How it would work on a Facebook group, right? Well, when anyone can read any comments, if you are not preventing another person from putting a comment, and you are not prevented from putting a comment and adding information, right? As long as you're not kind of like flooding it with spam, as long as you say something that you want to say, it is privileged. So it's meant to be privileged with free speech as well. And also, it says as long as it's not malice. Now, at the time, the definition of malice at the time of this 1960 was what the dictionary term is, which is without cause. So if you don't have a complaint, you don't have a grievance, you don't have a case to make or a cause, then So effectively, really, it's almost similar to the right to petition. You can see this in effect in America. They have people in meetings in America, and you have some people swearing, and they've got a legal right to speak, because in America they've got freedom of speech, right? So you might get some people sometimes getting angry and swearing, right, when it's their turn to speak. So properly enforced, it is privileged. As long as you're making that speech, if you are angry about something, then you can express that anger, because that's your response to the issue, right? Malice is without cause, so it's like you don't have a complaint, you don't have a grievance, you don't. It's not part of the representation, right? Or it's unassociated or unconnected with the business at hand or the matters at hand, right? And this is when actually sometimes people get removed from local council meetings wrongly by police, or police overstep the powers. It is actually privileged. It's got to be malicious. On the Public Meeting Act, you've got to be preventing other people from giving their evidence. Interrupting them might not be something to get removed for. Like in America, there was a person shouting out in between Robert F. Kennedy Jr.'s speech the other day, right? They did get removed, but actually, they can call order, and also, if you think about it, in a parliamentary committee meeting, which there are a lot of them on YouTube because Parliament have got a channel for all their debates, right? What they do is, when these MPs, members of Parliament, are giving evidence within a committee meeting, some of the other members actually interrupt and ask if they can give way or whatever, right? So it exists. You can actually ask to give way and interrupt, and it does actually disrupt a lot of the flow of the proceedings, I find, in the House of Commons petitions meetings. I don't think they like doing those debates, to be honest. I think it's a facade, like Dominic Cummings said, and there's a lot of arguments about the Petitions Committee and how it's being run at the moment anyway, which is another subject. But effectively, what they're doing, if you watch them in the Petitions Committee when they're having a debate and they interrupt and they say, "Oh, can you give way?" That's effectively, I mean, if you're going by the law, maybe that maybe that person in the audience at the back in Robert F. Kennedy's speech, maybe they were effectively, they got something to say about what Kennedy said. So maybe they were asking him to give way. Of which he kind of did stop, and then the chairman had them removed by the security guard. But, if they just said their thing and then he continued again, it wasn't necessarily preventing him from giving his speech, necessarily, because effectively they were really asking him to give way, right, for their comment. Now, maybe they don't have a right to speak in that meeting, or maybe it's like, in Parliament, obviously, you've got the audience, okay? You've got the audience aren't allowed to give evidence, only the ministers in those committee meetings, right? But there are other proceedings in Parliament when committees do summon people to give evidence, like Merlin Sheldrake, they summon him in, and persons who aren't members can speak, depending what type of proceedings it is. So it's interesting that Parliament have certain meetings where they're calling witnesses in to give evidence, like Merlin Sheldrake, right? They're wanting to sit in there listening to him, right? That is a committee taking evidence on certain matters. So I don't why they can't do that with the Petitions Committee as well, and have the petitioner speak and give evidence and all the work they've done and collected it in. Obviously, they'd probably submit that work beforehand and give it to their representative, and that's what they're meant to be saying and reading out, but they only read a very small amount of it out. The rest is meant to be officially submitted and obviously looked at by the committee in between, but they definitely don't kind of like have it spoken like with the Merlin Sheldrake thing. So what they're doing is they're doing it how it suits them. There are different formats you can have and how you could run that committee and how you could do it and present it. That they're choosing to do it, everyone's sat at the side on their good little baby seats and not say anything, just like listen. So I don't know. If America has got this constitutional law with freedom of speech, right, I don't see how these different states of America... Well, it was federal proceedings, wasn't it? Kennedy's was federal proceedings, wasn't state proceedings. It was for federal government. So if it's federal government, surely it's the First Amendment, and regardless of what regulations or policies the American government make, surely it's freedom of speech. And and Donald Trump said that he wants to get freedom of speech back. So in a way, really... if a particular person in the audience was that passionate about it, really, and Kennedy did give way, actually. He could have just carried on talking, and Kennedy could have just blasted straight through it. He stopped. And, they said what they wanted to say, but they were kind of like going on a little bit, and then the security guard removed them. So, it could have been within the rules, to give way under the Constitution. I don't know. But... it is meant to be privileged. At least you can't be arrested or prosecuted. Maybe if they do remove you for disrupting the proceedings, but that's under the Normal Public Meeting Act, not under this one. It's under the Normal Public Meeting Act. Apparently, if they do have the public and invite them, they are privileged, so they're not really meant to be arrested. If it's privileged, right, and you can't be arrested or imprisoned unless it's malicious without cause, then it's actually additional to the Public Meeting Act. So that's just this is where the police don't really know about or ever use the Normal Public Meeting Act, and we'll go on to the difference between it now. But what this act does is this act has, once the public are invited, it officially states that it's privileged. It's a privileged meeting, right? So that means that if you're there and you're there for matters to make a case, it's privileged, right? So you're privileged, so you can't be arrested or imprisoned, as long as it's representations on matters of the case. And that's what I think the police sometimes misunderstand. And I don't think they grant privileges. There's a lot of things in the meetings which are not malice. When the Police and Crime Commissioner candidate for Gloucestershire, I think the police were going to remove him from a meeting for the Police and Crime Commissioner's business affairs and so forth, and that police officer and security guard didn't really know the law properly. But we'll go back to the act that was before this, the first and earlier one. So this is the Public Meeting Act 1908. Okay, this is the original form of it here as well. Public Meeting Act 1908. So 1908 is an interesting date because the Parliamentary Papers Act 1840, which is a very, very important act of law in England, actually before Erskine May did his book for parliamentary usage of Parliament, the Australian government made a Parliamentary Papers Act themselves in 1908, which mirrored the UK government's one from 1840. 1908, therefore, is an interesting date because this Public Meeting Act in England is made in 1908, right? And it's very significant for these type of bodies coming together, particularly for political causes, petitions, any affairs to do with anything legal or council or whatever you want, really. Now, the police don't really know this act or use it. I've had the phone put down on me from a police officer before when I tried to get them to do something through this act. And they thought that I was talking about the 1961, and they don't even know about the privilege part of it properly, really, or what privileges even are. So now this act, all this act does is make it so if any members of the public, right, that is absolutely anyone, any citizen in England, any elector in England, right, if any number of electors come together and they are holding a meeting over something and no one to say what the meeting, it can be absolutely anything, right? There's no, what makes it official or not official, all this stuff the police are talking about, it's got to be like a government body or official. That's the 1960 Act, right? That's not this one. This is our law for us, right? If we, the people, are having a meeting, okay, no one can be removed from that meeting or prevented from giving evidence, right? But obviously, someone is usually directing it or in charge or whatever, but you can't be prevented from giving the evidence or taking part. And that is law in England, okay? Unless you try and prevent someone else from giving evidence or you try and remove someone from it, okay? And the police can't even remove anyone from it. As long as it's lawful. What does that mean? Well, it means that as long as no one's breaking the law, okay? Now, what would be the situation without that act? Well, without that act, okay, people could be stood around having a meeting, let's say, in the town centre, okay? And they might not be breaking the law at all, but they might just be there having a meeting, right? And then someone could remove them, okay, or prevent them saying something, even if they haven't done anything wrong, okay, or broken the law, right? So that means that no one can remove them. Why would anyone want to remove them if they weren't breaking the law? Maybe break up the meeting. Now, this is when the police come in with all these writing a dispersal order, right? But if they're not breaking a law, then the police officer had no reason to write a dispersal order, like flat harassment or anything like that. Now, this is when the privileges come in. Now, remember, okay, let's really remember the Tumultuous Petitioning Act 1661, because this is extremely important to the whole thing, right? From 1661 till 1986, okay, you are not allowed to get over 20 people consenting or signed to a petition to either Houses of Parliament or the King, okay, without consent from a court. So if it's not to His Majesty the King or to the House of Commons or the House of Lords, you're all right, okay? Now, the local council chamber isn't the King. Now, there's a bit of, is it the King's writ? Is it, is it the King's writ? Because if it's a criminal charge, if it's a civil charge, is it the King's writ? Is a local council chamber the King's writ? That's debatable, but you're not giving it directly to His Majesty the King or his Privy Council, and it's not to the House of Commons or House of Lords, right? So, this is when it comes to local council authorities. Is that why they made that 1960 Act? So it does cover local council authorities, and then they did say it was privileged, right? That's one thing to consider. But that was 1960. We're talking about 1908. So if you were, this is like William Penn, tumultuous disorder, right? This is critical for William Penn and his tumultuous assembly in the street, right? That's why he was in court in the Old Bailey, because they were having loads of people having a meeting in the street and they were trying to make out that it was to either Houses of Parliament or the King, right? But the jury said they were just talking in the street. Now, as long as it's not to either Houses of Parliament or the King, right? What happens if, a lot of people are going to decide, if they want to, go on holiday or something, or this is questionable with the local council. Is the local council the King, His Majesty's government, or not? That would have been a questionable thing. I don't think they were treating it as such. And I don't think they were treating local court cases like local crimes, because, you had hue and cry and you had to get a lot of people together for hue and cry, right? But you were going to end up in court anyway if you were chasing a criminal under hue and cry. Someone's going to end up in court over it anyway. So that 1960 Act clears up that cloud, that question, because, you can have that question. Is a local meeting that people are having, whether they're going to oppose the council on something or whether they want, something like that, is that to the King or not? Or is it not to either of Houses of Parliament or the King? So I can see how that 1960 Act kind of clears up a little confusion with that. But also it does say it's privilege, so they're giving you privileges anyway for those certain authority matters, even though it's not Houses of Parliament privileges as such, if you can follow this. So a lawful meeting then, so let's say 1908. So in 1908, once this is enacted, right, let's get this clear. if you're in 1908 and they've made this act, and you get 50 people in public, and you want to petition government, and you ain't been to a court to get consent, that is not a lawful public meeting. Okay, it's not lawful because you haven't got consent from a court, and it's like you're seriously looking like you're getting people to consent to something, right? So it's like you're in the William Penn situation, all right? Now, this is the interesting thing. If you have got, 30 people together in the street and you're deciding, whether or not to go on holiday somewhere, a group holiday, or I don't know whether you should start a business together, or whether you should bring group litigation against someone who owes you some money. Is that the king's route or not? I don't know. But it's not an actual authority. You're just a party, aren't you? You're not a government body or a certain particular authority. You're a party, possibly a number of electors. That's the 1947 Act to do with 3 or more electors can assist as a prosecutor. That's not to a local government body. But the thing is, with that, you're going to a court anyway. If you've got a group of people who want to intervene in a prosecution case, that was in Scotland, by the way, through that act, you're going to a court. You're all going to a court anyway. If you've got 40 people who want to do group litigation or act as prosecutors and intervene in a prosecution, right? You're going to be doing it in a courtroom, so you're taking yourselves to court, right? That's what you've got to get your head around. Okay, it's not to either of the Houses of Parliament, though, or directly to the King. I think that 1960 Act would suggest that they're making that act to cover particular local authorities and bodies, which are His Majesty's local governments. So, but there are loads of other reasons you could be having a public meeting, like, maybe there's going to be a festival in the village, right? That's a good idea. Or a music, a folk, or an art show, right? Okay, maybe the village is going to have a fair or an art show, Maybe they might have to pass it through the mayor or not, but maybe they don't, depends, Maybe one of the barons or lords has got his own private house, and he might be having a tea party, and you might be going to be inviting the village, and they might be having a meeting whether it's going to make too much noise or not. Anything like that. So that's lawful, right? As long as no one's committing an offence, the police can't come along and remove people from it or prevent them from giving information, right? Now, with the House of Commons petitions and House of Lords petitions, or to the King and Council, right, which is another tumultuous act, if you go to the court, okay, and you can have 3 justices or a jury, so it could be the public themselves who give you permission, it doesn't have to be a judge, it can be other members of the public, but, officially, in the court, but you had the jurats as well. It might not have been like a random jury, it might have been the jurats, but you got grand jury, I think, so, right, you go there, and you get permission. Now remember, you don't need permission if it's under 20 people, and you can write what the hell you want on your petition and send it into government, and if they don't want to debate it, then, tiddlywinks. So, but the court, right, this is getting the consent. How do you get the consent? Well, this is the thing. If you got before 1688, you didn't have an explicit right to petition the king, without being held to any commitment. So, I'm starting to realise now that you didn't necessarily have the complete and total freedom of speech. So the court might have been able to deny it, but you could do this bill of exemption thing in the court where you could complain about the justice to the king anyway. So whatever happens, that petition really could get through to the king, right? But because the justice had tried to obstruct it. But I in my head, he can't really obstruct it, depending if it's on a point of law or right. And if you've got the right, you're bringing a case. But after 1688, you've got this explicit right to do it, but then you've got all the freedom of speech things that are thrown into it as well, and you can't be held to any commitments. So the court really can't hold you to any commitments to make amendments or modifications to your petition. And they wouldn't be making any modifications to it anyway if you were just doing it by yourself or with a couple of people, because they wouldn't have anything to do with it. It would go straight to Parliament, right? And I've seen some Parliament read out some petitions which are erroneous or wrong or whatever and so forth. And remember, after 1840, they're not bothered if it upsets anyone or if it's vexatious or offending or defamation or harassment, because they've just created a law that protects everyone with a certificate that, you know, you can't be prosecuted by civil or criminal charges, which is what they use for Hansard. So, you know, and at the moment, the Parliament are really not using that. In fact, they're going the other way. They're going to this liberal Democrat wokeness, new can't say anything, can't say boo to a goose, where it's completely the other way. You're completely armoured and protected to say what the hell you want without getting prosecuted or fined or charged or anything. But Parliament, they're not giving you that. They're going completely the other way. So what the whole point of the law is to protect you. Why? Because it's politically and they don't want you to win. And they don't want and they don't want the public to have a strong case and win. And anything that makes a political parties look bad is bad for the party. But you know, that's the weakness of having a big party, because you know you're at risk all the time. You know, if the whole party looks bad, if every single MP is independent and one of them is made to look bad, then it doesn't affect the other ones, does it? You know, or less. So it's almost like having a big you know, kite and getting blown away, or a big sail or parachute with all the Labour Party attached to it, you know. And if a big gust of wind comes by, it blows a whole lot of them away, which that's their problem, you know. They think they're a brick wall, but they're ending up censoring people's stuff when someone's got a strong gust to pull them up on, you know. So I don't think they could deny it in the court, really, but you actually get consent. It's unlikely that the general public aren't going to give you consent, though, and I think that after the 1688 Bill of Rights, you can't be held to any commitments. I think, really, you're just going in there to log it all and get it written down and recorded and getting, you know, they want to know what you're up to, what you're doing, and who's involved and all that kind of stuff. But it gets consented to, so that's an order, right? So you've got a court order. So then you're armed. This is like, you know, Mr. Bill Armour, you know, from Kirklees Council. Bill Armour, you're armed, your petition's armed, right? So then, when you're having a public meeting, then it's lawful, right? Because you're not breaking the law of the Tumultuous Petitioning Act, okay? It's not a tumultuous assembly because you've had consent, okay? So you can go about collecting more than however many signatures you want, and it's privileged, like in the 1961, but not with a local authority, and not necessarily has to be indoors or not. Although one of those authorities could quite readily have a meeting outside if they wanted a view on something, like, you know, in a park or whatever. They can have on-site meetings if they want to, you know, show people something. So, you know, I've seen local councillors walk around with an entourage, you know. I don't know who the hell the entourage is, but they've got an entourage, like parish councillors even, you know, with, you know, a group of, you know, 6 ladies, you know, or whatever, going around, walking around the village with a notebook or a clipboard or whatever, you know. So this is it. This is when your public meeting is not only lawful. So it's not unlawful through this act here, this 1908 Act. It's not only a lawful meeting. Once you had consent from the court, you're then petitioning either Houses of Parliament or the King officially, right? So this is usage of Parliament because you're collecting evidence in an official cause, which is going to compel the MPs to debate it. And also possibly any other evidence, and also advertising it, because you can't get any more signatures if people don't know about it, you know. So you talk about it, shout about it, put it in the newspaper and so forth. So this is where your privileges come in. It is because if you didn't have that consent, it would be unlawful. But when you've got the consent, it is not only lawful, it is lawful and privilege of Parliament, which is where your 1840 Parliamentary Papers Act comes in, particularly when you're putting it in the newspaper, right? And that's not what's getting happened. Now, when they scrapped that act in 1986, when the Crown Prosecution was formed, like just around, it just been formed, okay, 1985, they scrapped that act. So did it mean that you didn't get privileges anymore? No, it meant that when you had a meeting in public and you were doing it to the Houses of Parliament, it wasn't unlawful because you didn't need consent anymore. So when you're having a meeting to the Houses of Parliament, you're not having an unlawful meeting if you haven't got consent, because you don't need it, right? Just like previously, you could have, 8 people or whatever without consent. So you didn't need consent then to put it in the newspaper or make leaflets. Now, this is the thing, putting it in the newspaper. So if you put it in the newspaper and you've had a court order to say this is, cause to Parliament, and they sent a report to the Speaker or whatever, you should be entitled to use that Parliamentary Papers Act 1840 if challenged. If anyone prosecutes you for defamation or harassment or whatever. So that means the newspaper can't be prosecuted, right, for that petition advert. So why would the newspaper refuse putting it in there? If out of all the people who are going in the newspaper, like various stories, items, features, business adverts, buy a deck chair on the beach, build some sandcastles in Blackpool, whatever, right? Why would the newspapers say, oh, we're not going to publish it if you can't be prosecuted? Because they wouldn't be liable for any charges, right? Now, the only reason why they might not put it in there is if they're wrong on their law and they think that it's unlawful, but actually it couldn't be quite the contrary. It cannot be unlawful unless the newspaper's personally opposed to it, which, now this is the thing. There are lots of laws in England where a local authority puts a notice in a newspaper and it has to go in there by law. Whether the newspaper likes it or not, it has to be put in at least one local newspaper, okay? Now that's enforceable by acts of law, because it's an authority. When you're petitioning Parliament, you're acting with authority, right, of it, the 1661 Bill of Rights, okay? And this is the thing. What do newspapers have to do with governments and authorities if it's a completely private business? Well, courts make orders against newspapers regularly. You shall not publish this or that, okay? Well, there are orders to the contrary. And this is what MPs at the moment aren't. I don't think that they're that intelligent enough to know it unless you explain it to them. They're not going to have the initiative to work it out themselves because they're groomed, trained, conditioned, staff training. The modern Parliament staff don't know. The clerks don't know because it's pre-1985 basically. Unless you explain it to them, right? Parliament Petitions Committee have got powers, okay? Powers. They've got standing orders, 145A3, which is to compel documents, persons, information, right? Summons. They're given court powers of summoning documents and people, okay? Like a tribunal. And it's to compel information, but also it is to produce documents, right? Now, if you are a witness or a human and someone asks you to get a pen out and write a statement, okay, that you're producing a document, you're manufacturing it, you're producing it, it comes from your brain, right? And instead of a machine printing it, you do it with your hand with a pencil, right? I've just produced a statement, right? Now, what is an advertisement? It's a piece of paper, a sheet of paper with writing on it, a document, right? So you've got power to compel information, documents, make people produce documents and information, right? Or appear to produce it, right? Now, this is where, well, who do you need to produce that? Well, a certain person who knows something or has something that you want or need, okay? Now, this is like the 38 Degrees website as well, right? So, an advertiser, a printer's, right? Have they got something that you need, right? If you are investigating a crime or even just a public inquiry, right? Well, this is the thing. They've got something that you want or need because they've got a lot of ink and paper, right? Because you might not have any ink and paper, and they might have more than ink and paper. They might have a pallet full of ink and paper, right? And you might need that ink and paper to be produced in notices, right, to give out to people. So, right, produce me information, 10,000 sheets of paper which say we are looking for witnesses who have information about the ULEZ scheme, information about an incident that happened on the 5th of February, about this or that, okay? We are asking you to produce for us information on paper which tells the public, right, to come forward if they've witnessed any persons or anyone who knows any knowledge of this to please come forward, right? Produce 10,000 of them and give me them, bring them, send them to Parliament, right? That is compelling information to be produced, right, from an individual, right? Or you can say, tell me what you did on Tuesday or on the 6th of January, right? Or whatever, at 3 o'clock, right? Tell me what happened, right? Produce it onto a piece of paper, right? Information. So this is it, right? So this is what we're doing. Produce me 10,000 stickers which say, HM government on, right? Stamp pads. Or, produce me 10,000 documents which say vote for Labour. Oh, no, I can't do that because that's illegal, because then I'm supporting a political party. The Prime Minister cannot use government funding to produce 10,000 vote Labour signs, but he can say 10,000 signs, apparently, which say, wear a COVID mask or something. So this is a thing, right? If Parliament didn't have that power, then every business in England could say, we're not producing you anything, right? So Parliament wouldn't have any paperwork, document, stationery or anything. This is why they've got the stationery office in Hansard, right? Now, the thing is, when we petition Parliament, right, as Erskine May says, it is usage of Parliament, right? I am petitioning Parliament. Now, if you go to, if you want to prosecute someone, it's usage of the Magistrates' Court. It's usage of the Crown Court. If you want to claim £50 from a plumber, right, you use civil court. It's usage of the court, right? How else am I going to do anything if I don't have any power? That's the point of using a court. It compels people to do things, or there's no point having it, right? Usage of Parliament. So Parliament is meant to actually back us up with compelling other persons to produce information and documents, not excluding a newspaper like the Trinity Media Press, who are refusing to answer emails, who are refusing to answer telephone, who have got an advertisement of mine which they won't reply to me about or give information on, who won't publish an advertisement in South Wales for a petition when it's freedom of speech, when it cannot be prosecuted or sued against, right? Prior to 1986, yes, they had lawyers, night lawyers, who had to meticulously check things, because remember, if you put a petition in a newspaper before 1986, asking people to sign it, then the newspaper could say, oh, we can't put it in there, right? There's lots of legal technicalities, right? We have to check the law, whereas as night lawyer, because if you didn't have consent, but after 1986, you didn't need consent from any court, but yet it's still privileged because it's usage of Parliament. So, bonus, there's nothing can stop you from putting in the newspaper, right? Not even the newspaper, because, Parliament are going to back you up, but they're not backing us up. And this is a problem, right? Firstly, They don't really understand it properly. Secondly, they wouldn't even want to back us up even if they knew they could, because remember, they're not even publishing petitions now which they don't fancy or care too much about. And that's the problem. The Parliament Petitions Committee now themselves, even though we don't need consent from no one, right, have taken it upon themselves to have their own website publishing our petitions for us, saves us the trouble of putting them in the newspaper. But instead of us having the right to petition without being held to commitment at all, they're deciding that before we can go about the business that is meant to be our private, personal right to go and collect as many signatures as we want and then hand it in and compel them to debate it, they're letting us submit it before we've got the weight of force to compel them, and they're not even letting us write what we want or say what we want, okay? When we can't be prosecuted for it in civil or criminal charges, even if it upsets anyone, right? Because they don't want us to win. Now, this is the problem. Yeah, it's privileged except for malice without cause. Well, you've got cause if you've got a petition of grievance, I can tell you that. So the Petitions Committee, now this is another new phenomena, because the Petitions Committee would not be able to do this before Tony Blair. Tony Blair started the 10 Downing Street e-petitions website, right? Was it 2006 or something, or 2010 it might have been, right? Well, it's called the e-petitions number 10 Downing Street website, right? So at that point, up till then, no one ever would have anyone change the words of their petition, particularly if it was getting under... if you were doing it just yourself, right, and getting a couple of 5 people to sign it, right? No one changed your words or altered your words at all. It was not known of, right? And you hand it in, and that's it. It's done. If they don't want to debate it, they don't debate it, but it's not changed. The words aren't changed. And like I said, there's loads of petitions being read out that are erroneous or whatever. They just say, oh, this bit's questionable or whatever when they're reading it out, right? So, and obviously, if you're getting lots of signatures, you have to go to the court and get consent. Now, this is what I want to find out about. Sometimes the courts did their own petitions on behalf of the whole public, and they helped them do them. Sometimes the local councils did them to Parliament. It's not just us. Lots of local authorities petitioned Parliament. Lots of judges petitioned Parliament themselves, and had their own kind of like important people in the town getting around, and they worked out what they were going to say and the wording for it. But you could still do your own as a group. Now, this is where the questionable part is. It could be 3 justices, but it could be a jury. If it's the grand jury and the members of the public, then it's the members of the public that decide what if you have, what you're saying or not, whether they consent to it or not. Now, I need to find out whether or not they were making people change their wording or not, if they went big and went for large number of signatures, given in the fact. So, this whole phenomenon of kind of trying to coerce people to edit, change, alter the wording of the petition writ, which was really near impossible to do if you writ it on paper through prehistory, right? Is a completely very, very modern history phenomena going only back to 2006, right? I thought it was 2010. It's 2006. I only find the archives going back to 2010 on the government website. I like to try and find where the 2006 archives are. So 2006, yeah, I mean 2006. So this whole phenomenon of saying, oh, you can't, have this or that petition, but it's not the fact of rejecting it, because remember, you could always write a petition yourself or with a few people and then just not act on it. But what they're doing is they are hijacking, or they are they're seizing or taking over a part of a process which is inherently ours. We've got our own special right in law protecting it and facilitating it. And it is the merging together, the meeting of the Parliament privileges of Parliament, right? And you submitting and sending that complete to them, right? And then them taking on the case. But they're not meant to take on the case until you've finished collecting all your signatures, or how many of every signatures you want. The more signatures you've got, then the more compelling it is, regardless of what the writing is, because then you've got a very, very large number of people supporting that writing to be fact or truth, or that they want some action on it regardless of what it says, or that they think it's right, or that they're claiming it's right. But rather than the government, just saying that one person's wrong. When there's like 10 million people agree that a fact is right based on their statements, they've got to entertain the idea and then debate further. It's the debate that decides whether something's right or wrong. And what the Petitions Committee are doing, and now they're kind of saying like, well, we're going to decide whether it's right or wrong in the committee when you've submitted it, but that isn't an official debate where you get to hear what they've said. And another part of this, actually, this revelation came today. This is like a new revelation of something very obvious and clear, right? When you submit a petition to Parliament now, right, they say, okay, that if you get 10,000 signatures, the government will respond, will comment on the matter, right? Well, that should include the actual petition itself. What's happening is we're submitting petitions and then they're actually rejecting it, but they actually give you a comment, they respond, right? So the actual email of rejection is a response. Yeah, it says they'll only respond if you get 10,000 signatures, but you're not even allowed to collect 10,000 signatures. They won't let you, right? So that there's something wrong there. And even though they've got this policy saying it's got to meet the standards and so forth, you need to accept them in the standards, what they're actually doing is they're actually giving you a response to the petition. It's a response about the subject, and also coming out with, reckoning they don't understand what you're asking, or they can't do what you're saying, or there's something erroneous in it. But nonetheless, it's a response, right? But they're reckoning that they're only going to respond if you get 10,000 signatures. But they're not. They're responding if they don't like it. So that's a lie. Not from me, from them. They're lying that they won't respond until you get 10,000 signatures, right? In fact, the truth is they're actually responding when it's something they don't like or when they don't think you're right, but they're not actually giving you an official debate, right? And if they're not debating it, why does it matter if it's right or wrong? It's a claim at the end of the day. But this phenomenon didn't exist. What they're trying to get you to somehow edit it, change it, or ask for it in a different way using different words or language. That didn't exist before. And at the end of the day, the most valuable attribute of the petitions in the collection is the caricature of all these people. It's like, history groups and schools and colleges are studying these documents to learn about the history of England. They wouldn't learn much about the history of England if it was some like anal kind of like AI bot, or and a lot of universities now are just taught to do these graphs and charts, 15 petitions in, litigation and 100 petitions in this or that. And all that actual information I don't find it very useful at all. I find it quite anal. When I actually read through the petitions, every single one is like a story. It's like a saga, a tale, a person in a life situation, in a predicament, that they're in prison, or that they're in a sheriff's cell, or they, some servant, went to buy a hat and tells a story. It's actually a story of someone's life. Someone made the king's servant a hat, and the servant never paid him the money, and he tried to get the money back, and then the servant claimed privileges, and it's like a little novel, a little story, and all these peculiar details and informations. in and around it, you're actually learning. In fact, this is how I'm learning about petitioning, because, it says, he claimed the privilege, but when I went into the sheriff's office, I found no privilege up there for this particular servant. It wasn't there, so I'm asking if I might proceed against them. Valuable information. Now, it's like they want you to, can we, change section 345 of the, Horse Racing Act or something, and that's it. It has to be like, it has to be like some kind of computer coding command. You can't add any irony or humour in there or anything. Not to say that it's not, swearing or anything, but this is the thing. And they say, they don't even accept hardly any links. So as soon as you put a link in, unless it's a government link, they go on as, this information is not verified. Well, that's why I'm trying it. We want it verified. We want you to debate it, and then the ministers to look into it and check it. Well, apparently they're checking now before they publish it. But where's the evidence that they have checked it? What they're doing is, a very large number of signatures is extremely powerful, and they're not letting you act. They don't want you to be able to use Parliament's website to get that weight of power in something which they don't like or don't want or don't agree with. But you're getting them to agree with it, and you're making them like it with the weight of signatures, right? That's what makes them do it. And that part of it isn't their right. The accumulation of the signatures part isn't within the parliamentary privileges part of it on their part. It's within the 1688 Bill of Rights, our part, which plugs into that and loads the signatures into the House of Commons part of it, right, through the port. And what they're doing is they're facilitating a process which arrests our part of the process and puts like a guardian over it within Parliament when it's completely free. And the 1661 Act is repealed, and we don't need any consent from and usually you could get consent from a grand jury, It's not just His Majesty's Justices or an elected member of Parliament who decides what's consented to collect all the signatures. Actually, the public decide. So surely it's the public signatures who are signing it, who are saying, whether or not they consent to it or not. But just look at this Michael Westwood petition that's got 3 million signatures, and then the MPs are saying that, these particular, they can't debate the seats of members or all of the seats of members, when I think they can. And there's a university paper that proves that as well. It definitely is within the right of Parliament to debate its own seats, and they only opened it up to the courts. Or there are a few acts in between. There are some strange acts in the 1700s, but up till 1868, it's not officially opened up to the courts. There was something going on in Westminster Hall, but Westminster Hall was sort of considered to be. Parliament tried cases in Westminster Hall at the King's Bench, so it's a special jurisdiction, is Westminster Hall, and you can have offences which aren't necessarily affecting the MP seat. You can have an election which has particular crimes of members of the public involved, but don't necessarily affect the seat of the MP or involve the MP himself. So some of those cases I think were tried at Westminster, but for sure they definitely can debate it in Parliament and in the Chamber. So it's a new phenomena. Actually, from 1986 up till this 2006 website, that there shouldn't have been any modifications or changes to petitions at all whatsoever. So. And definitely not. It's kind of like blackmail in a way. It's like it is blackmail. It's become blackmail because what it's become, it's like, word this petition how we want it to be worded, okay? Or we're not going to let you. We're not putting it on his website, and we're not letting you collect the signatures unless you say it how we want you to say it, or not include certain things that we don't want you to say. Right? When they're not swear words, vulgar, necessarily, and anyway, public meetings are privileged. Even in the 1960 Act with a local council, they're privileged except for malice, which is without cause. So if you petition in Parliament, you've always got a cause, right? So it's meant to be privileged. They're not giving us the privileges. And the thing is, in the House itself, rules of the House is for debating the House, not trying the case. And nonetheless, what's the point in having the Parliamentary Papers Act, which protects you from defamation or whatever, if you're not going to use it? It's completely pointless having that power, So, and as for the etiquette of Parliament, the 1688 Bill of Rights gives members complete and total freedom of speech in law, right? The rest of it is purely etiquette and up to the Speaker's headmastery, right? It's like the Speaker's headmastery over it, If everyone in the House of Commons, suddenly thought that, swearing was cool, right, then that would be, what it was. The ironic thing is that some of them exhibit some extraordinarily odd, peculiar behaviour, like with this ceremonial behaviour, like grabbing the Speaker and dragging him onto the chair. It's ceremonial, but it represents the fact that they can't be punished, that, they can be unruly because they got the freedom. They like to do the unruliness, ceremonial unruliness, and then, this weird hyperactive child behaviour, like stand up, sit down, stand up, sit down, stand up, sit down, like, or what odd woman acting as if she's possessed or something, an exhibitionist or something, right? Or he walks in and picks up the mace and tries to walk out with it or whatever, right? And you got Burkhouse shouting, order, order, order. But it's all, when's the last time any of them, got sent with a sergeant at arms and locked them up in the cells until they behave, This is the thing. So, and there's probably many instances where MPs can read something out and just excuse themselves and say, I will quote the, you might have to quote something, in Parliament there might have been an incident that happened and you might have to quote it and it could be, it could be, questionable language or whatever, but they say, they say, excuse me, but